South African deepfakes landing people in jail, politicians in bikinis, Meta losing a case in Nigeria, and Toyota sued for leaking information. This is Priviso Live. Hello everyone and welcome back to Priviso Live. I'm Lynn and joining me as always are Stephen and Kayla. How are you both doing this week?
Not too bad, Lynn. Though I must say, after reading this week's stories, I'm seriously considering going back to a flip phone and a horse and cart.
Stephen, you'd probably find a way to get the horse's biometric data leaked somehow. But this week's lineup focuses quite a bit on privacy. We've got AI deepfakes landing people in jail, Meta getting hammered in Nigerian courts, and Toyota apparently moonlighting as a spy agency.
Quite the trifecta. Let's dive in, shall we? Kayla, why don't you kick us off with the local story? Because nothing says welcome to 2026. Quite like getting arrested for sharing memes.
Right, so My Broadband published this piece on the 8th of January about how sharing certain videos and images online can land you in serious trouble here in South Africa. And I'm not talking about just dodgy content. We're talking about AI-generated images, deepfakes, and even sharing fake emergency content.
I saw that one. The example they used was quite hectic. Someone created an AI-generated image showing Orlando West High School on fire. Completely fake, but emergency services rocked up anyway. Can you imagine the resources wasted?
Exactly. And Johannesburg EMS came out swinging, warning that creating and sharing fake emergency content, especially AI-generated stuff, can have serious legal consequences. They're not playing around.
And this isn't just about wasting emergency resources, is it? The article mentioned some pretty serious criminal penalties.
Absolutely. So there was this case in KwaZulu-Natal in May last year where a guy got sentenced to 5 years in prison for sharing altered pornographic images of well-known people. 5 years. And here's the kicker. South African law doesn't differentiate between real and fake images when it comes to these kinds of harms. It does remind me of the UK grok issue and the images of politicians in bikinis.
Keir Starmer did get his knickers in a knot, didn't he? Even after Elon moderated the image creation.
I'm one of those who has to query why Mr. Starmer chose only the one platform where he faces regular criticism, given that these images can be produced on many LLMs. But coming back to the South African issue, whether you've created a deepfake or you're sharing one, the law treats it the same as if it were real, and liability attaches to creating, possessing, and distributing these images.
So, Stephen, walk us through the actual legislation here. What laws are we talking about?
Right, so there are two main pieces of legislation. First, you've got the Cybercrimes Act, which makes sharing an intimate image without consent a criminal offense. Then there's the Films and Publications Amendment Act, which is even more specific. Sending or distributing a private sexual photo or video, whether real or fake, without prior consent, can land you with a fine of up to 300,000 Rand and up to 4 years in jail.
300,000 Rand. That's not a slap on the wrist, that's a proper clap.
And I think what's particularly concerning is that the article mentions criminal capacity in South Africa starts at 12 years old. So even teenagers can be held liable for this stuff.
Yeah, they mentioned alleged arrests of teenagers for creating deepfake images of girls at their school. It's a massive problem. And I don't think young people fully grasp the legal consequences.
It's scary, hey? Like, when we were in school, the worst thing you could do was pass a note in class. Now kids are potentially facing criminal records for sharing AI-generated content without understanding the implications.
It really highlights the need for digital literacy education. But let's move on to our next story because this one's got some serious implications for the tech industry across Africa. Stephen, you wanted to tackle the Meta ruling?
Yeah, this one's fascinating from a legal perspective. So TechPoint Africa reported on a Nigerian court ruling from January 13th, just a few days ago, where Meta was ordered to pay $25,000 to Femi Falana over what appears to be defamatory content posted on their platform.
Wait, so Meta is being held liable for something a user posted? That seems problematic.
Exactly. And that's where the experts are raising concerns. The court treated Meta as a joint data controller alongside whoever uploaded the content, essentially saying that Meta and the poster together decided to process the personal data by publishing it.
That's quite a leap, isn't it? I mean, platforms host billions of pieces of content. How can they be joint controllers for all of it?
That's precisely what legal expert Gbenga Odugbemi is arguing. He says this dispute is fundamentally about false statements and reputational injury, which would traditionally be handled through defamation or negligence law. Using privacy and data protection law for this is what he calls a doctrinal shortcut that might not hold up as precedent.
So what are the practical implications here? Like, if I'm running a startup with user-generated content, should I be worried?
You should be very worried. Advocate Durancio Mohale flagged that this approach could be too broad. If platforms can be liable merely for hosting or algorithmically distributing third-party content, they're going to respond by removing content preemptively, including lawful speech like satire, criticism, political commentary, investigative reporting.
So, we're talking about a potential chilling effect on free expression?
Absolutely. And here's the thing. Large companies like Meta can afford expensive moderation and compliance systems. But local African startups, this could bankrupt them. The experts are concerned about a flood of lawsuits and higher compliance costs that could kill innovation in the African tech space.
It's that whole can't find the speaker, so sue the microphone problem, ne? Just because the original poster is unknown or hard to identify doesn't mean you should shift liability to whoever provided the platform.
Exactly. And Odugbemi makes that exact point. Difficulty finding the wrongdoer shouldn't justify reassigning substantive liability to a more convenient defendant just because they have deeper pockets.
This is going to be one to watch. If this precedent spreads, we could see big tech firms limiting investment or even exiting certain markets, which would reduce access and connectivity for users across the continent.
Right, and that's the last thing we need. Okay, shall we move to our final story? Because this one is wild, and it affects anyone driving a modern car.
Yes, the Toyota lawsuit. Kayla, you've been digging into this one?
I have, and honestly, it's made me look at my car very differently. So there's this guy in Florida, Philip Sifke from Eagle Lake, who's suing Toyota for more than $5 million, alleging that Toyota's connected vehicle features collected detailed driving data and shared it with third parties, including insurers, without his clear, informed consent.
How did he even find out? I mean, most people have no idea this is happening.
So here's the thing. He applied for an auto insurance quote with Progressive and specifically opted out of their tracking program, but then he got a message saying they already had driving data associated with his vehicle. When he asked, Progressive apparently told him the data came from Toyota via a data pipeline.
That's quite invasive. What kind of data are we talking about here?
Location, GPS, speed, braking behavior like hard braking events, basically everything you'd need to score someone's driving risk. And the complaint alleges it could include even more granular stuff like seatbelt status and potentially even image and voice data from the vehicle's sensors.
Aish, so your car is basically a mobile surveillance device.
Pretty much. And it's not just Toyota. The lawsuit names Toyota Motor North America, Progressive, and a company called Connected Analytics Services, which apparently aggregates and provides this driving data.
What's the legal basis for the lawsuit? I assume it's not just this feels creepy.
No, it's actually quite serious. The complaint alleges violations of the Federal Wiretap Act, the Computer Fraud and Abuse Act, plus various privacy and contract-related claims. So while it's not cybersecurity in the sense of someone hacking into the system, it's definitely cybersecurity adjacent. It's about digital vehicle systems, data capture, transmission, third-party sharing, and consent.
And this is where it gets interesting from a legal procedure perspective. Sifke originally wanted to bring this as a class action, arguing that many Toyota drivers might be affected, but a judge didn't allow it to proceed as a class action in court because of arbitration terms and class action waivers in Toyota's connected services terms and conditions.
Ah, the old forced arbitration clause. So it's being pushed to arbitration rather than open court.
Exactly, which means less transparency, no public precedent, and it's much harder for other affected consumers to join or benefit from the outcome.
This is such an important issue for our listeners to understand. If you're driving a modern connected vehicle, and let's be honest, most new cars are connected these days, you need to check your settings and understand what data is being collected and who it's being shared with.
Absolutely. And I think this ties back to our first story in a way. We're living in an age where data is being collected, processed, and shared in ways that most people don't understand or consent to. Whether it's AI-generated images, social media platforms, or your own car, the technology is moving faster than most people's understanding of the risks.
And faster than the law. in many cases. I mean, look at the Meta ruling. The courts are trying to apply existing legal frameworks to situations they weren't really designed for. It's messy.
Which is why conversations like this are so important. Our listeners are the ones who are going to be implementing security controls, advising on compliance, and helping their organizations navigate these issues.
Absolutely. So let's do a quick recap before we wrap up. Kayla, hit us with the key takeaways.
Right, so number one, if you're in South Africa, think very carefully before sharing AI-generated content, especially anything that could be considered intimate images or fake emergency content. The penalties are serious, and the law doesn't care if it's real or fake.
Number 2, the Meta ruling in Nigeria could have significant implications for platform liability across Africa. If you're running or working with platforms that host user-generated content, you need to be watching this space very carefully.
And number 3, your connected car is probably collecting and sharing more data than you realize. Check your vehicle's privacy settings, read those terms and conditions, and understand what you're consenting to when you use connected services.
And maybe consider that horse and cart after all, Stephen.
Yeah, except knowing my luck, someone would put a GPS tracker on the horse and sell my travel patterns to the local insurance company.
Enough said. On that note, I think we'd better wrap up. Thank you both for another great discussion, and thank you to our listeners for joining us. Remember, if you've got topics you'd like us to cover or questions about anything we've discussed today, reach out to us on our social channels.
And please, for the love of all that is holy, stop sharing deepfakes. Just don't.
Wise words. And if you need security, risk, or ICT legislation advice, contact Priviso Consulting directly at admin@priviso.co.za.
And if you have topics you'd like us to cover or questions about anything we discussed today, reach out to us.
Thanks for listening.
Stay safe, everyone.